Tonight, lawyers for Kpandai MP Matthew Nyindam file another notice of appeal and stay of execution as court release full ruling on the matter to buy more time for him in Parliament after Speaker's 7 days deadline expires today.
With an application of certiorari seeking to quash the judgment, because an appeal and certiorari are not mutually exclusive. That is what I can say for now.
But will the MP be allowed to conduct business on the floor on Tuesday? We'll hear from the majority and lawyers for the MP. This is Top Story brought to you always by Telecell, connecting energies. Also by Holy Insecticide Spray and Coil Enjoy, Holy Sleep, and by Short Pension. Trust into the future with you. Now, the fate of Member of Parliament for Pandai constituency, Matthew Nyindam, is tonight hanging in the balance as lawyers of the New Patriotic Party raise against time to file another notice of appeal and stay of execution on a High Court ruling. The Tamale High Court, presided over by Justice Emmanuel Plange Brew on November 24th, on a petition brought before the court, annulled the results of the 2024 Pandai Parliamentary election. In that particular election, the action of the court caused chaos in Parliament last Wednesday, where the majority insisted the MP must not be allowed to transact business on the floor. Listen to the Speaker's ruling on the matter.
The debate on the floor.
Honourable members, the effect of the order, to my understanding, is that the Electoral Commission is to conduct a rerun election within 30 days, implying that the original declaration of Honourable Matthew Nyindam as the winner of the parliamentary election is invalid, and the member is no longer a member of Parliament. I, however, bring to the attention of the House the provisions of the Court of Appeal Rules 1997 CI 19 as amended in the Court of Appeal Rules 2020 CI 132. Honourable members, is therefore premature to say that the Honourable Matthew Nyindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7 days mandatory stay of execution of the order. Honourable members, this is not a declaratory order, it is an executive order that was delivered by the High Court. And so the honourable member is right to have been in the House yesterday and to have participated in the proceedings.
Well, that was the Speaker ruling on this particular matter. The minority today has also launched a scathing criticism of the court following the Justice Plange Brew's failure to release the full judgment on the case on the Friday November deadline. He promised. My colleague Fatawu Bayaga joins me in studio with the excerpt of the particular statement. Bayaga. What does that statement say?
Yes, Brace. So the minority says Justice Emmanuel Plange Brew's handling of the Pandai election petition is deeply troubling, especially his failure to deliver the written judgment he publicly promised. Now, they argue it is unconstitutional for the court to nullify an entire constituency election when only 41 of 152 polling stations involving about 500 votes were challenged, despite the MP winning by a margin of 3,734 votes. So according to the minority, the judge's refusal to release the judgment after two formal requests has effectively paralyzed the appellate process and undermined public confidence in the judiciary.
And this statement, I must indicate, came in this morning before the release of the ruling some few minutes ago. But we are just learning that particular ruling, as I said, has come. And we can now hear from lawyer who led the case for Matthew Nyindam at the Tamale High Court, Sylvester, Isang.
The judgment is now out. I think some 30 minutes ago, we received the judgment of the judge. And it's out there for the whole public to judge for themselves. And even in the absence of the detailed judgment, we were able to file a notice of appeal. We were just waiting for the judgment to come to terms with the justifications or the reasoning of the courts, and which would inform us of further grounds of appeal to be filed with the leave of the court or further action. You see, if we read the detailed judgment and we see that there are jurisdictional issues or something like that, we could head to the Supreme Court or with an application of certiorari seeking to quash the judgment, because an appeal and certiorari are not mutually exclusive. That is what I can say for now.
So that was a lawyer for the MP Matthew Nyindam, Sylvester Isang there, speaking to us just when the judgment was released. We'll delve more into this particular matter here on Top Story, brought to you always by Telecel Connecting Energies, Holy Insecticide Spray and Coil, Enjoy Holy Sleep, and also by Shield Pension Trust into the future with you. Well, so we're still staying on Pandai because as the judgment has come, and we now know that lawyers for the New Patriotic Party and the MP have been able to file this appeal and stay of execution. I would want to find out what this means to the MP's performance in the House tomorrow when the House sits, whether or not he will still be able to hold himself out as a member of that House. We'll be getting legal education from lawyers and also members of Parliament for us to understand what this really means, because we now can confirm that lawyers for Matthew Nyindam have been able to file another notice of appeal and a stay of execution on the High Court's ruling. What does this really mean to the case, and whether or not the MP can hold himself out as a member of the House when the House sits tomorrow? We'll get to know. We are saying tomorrow because the Speaker's ruling, the 7-day mandatory stay that he got, expires today, which meant that if the lawyers had not been able to file this appeal, then he could not have been in the House tomorrow. But once they've been able to stay or file a stay of execution, we're asking, what does it mean to his participation in the House tomorrow? And so we'll be joined by the minority and the majority shortly for us to go on this particular matter. But you will recall that on the 24th of November, when the High Court announced the election result of the Pandai elections, the lawyers for Matthew Nyindam, the incumbent member of Parliament for Pandai, filed a notice of appeal and a stay of execution against the ruling of the High Court in Tamale, which ordered a rerun of the parliamentary election in the constituency. The High Court mandated the rerun to have been or to be organized within 30 days following procedural irregularities at the coalition center during the initial election. Let's go on the phone lines now and bring in Rockson-Nelson, Dafeamekpor, who is Majority Chief Whip and MP for South Dai. I'm grateful to you, sir, for joining us. Now, we know that the full details of this judgment has come out. The lawyers for Matthew Nyindam have finally also filed a notice of appeal and a stay of execution on the High Court ruling. I mean, will you still be on that, conviction that he still must be declared a persona non grata because that mandatory 7 days that the Speaker gave is expired today?
Thank you very much. One, it is most inaccurate for anybody to suggest that Matthew Nyindam is now filing a notice of appeal. In fact, what they've just done on this first day of December 2025 amounts to an abuse of the court processes.
Why so?
Because on the 24th, a week ago, on the 24th day of December, they had filed, on the 24th day of November, they had filed a notice of appeal.
Yes.
And followed it up with an application or notice for stay of execution. So if you come to the media today and say that you are now filing a notice of appeal and also filing an application or notice for stay of execution, they should be candid with everyone. This is the second set of processes that they are filing. So they are abusing the processes of the court. And we want the whole general public to know this.
But whose calling will it be? Whose calling will it be for, to describe that as abuse of court processes? Will it be the court?
No. It can be my calling.
Okay.
As a majority chief whip, I am demanding that Matthew Nyindam no longer participate in the processes of Parliament. And Speaker agreed to, but he said the applicable, the relevant provisions of the Court of Appeal rules will spring to life to ensure that there's a 7-day automatic stay of execution. That expires today. And so if you have indeed filed a notice of appeal and followed it up with an application or notice for stay of execution, why are you not relying on that? And you are filing another set of a notice of appeal and another application or notice for stay of execution. I suspect they may want to withdraw one. But to simply keep filing processes just so that Matthew Nyindam can stay in Parliament won't hold.
No, but that process they've begun, doesn't it stay your hand in trying to declare him a persona non grata?
At all. It does not. It does not stay my hand. Only a court order can stay the hand of Parliament. Only a substantive court order. Processes filed in courts. In the authority in Dafeamekpor versus Attorney General is very clear that a mere filing of a process cannot injunct Parliament from performing its constitutional duties or observing its undertaking its constitutional obligations. Parliament is now under obligation to write to the Electoral Commission. And the Electoral Commission, being a party to the suit, is also under a constitutional obligation to declare the seat vacant.
Why
must within 30 days for a rerun of the elections.
Must Parliament write to the Electoral Commission here?
Yes, Parliament, if you are served with an order, the effect of the order is that the seat has become vacant.
But I mean, it's good that you're a lawyer so you can help us understand. When someone files a stay of execution,
yes,
doesn't it take effect?
What sort of effect? It has no effect. The mere filing of an application for stay of execution, our courts have been called on many times, including me myself. I've been in the Court of Appeal, I've been in the Supreme Court. The courts have disagreed that the filing of the process does not stay in the court's hand. And I'm telling you that not just a stay of execution, an application or notice for injunction. I have gone to court to get Parliament injuncted. It didn't happen. The court disagreed with me.
So you're saying that tomorrow you will still ensure that Matthew Nyindam does not participate in the activities in the
I will
House?
not merely ensure, I will insist. I will not This is a substantive order of the High Court. Substantive decision of a case heard on its merits. This is juxtaposed that with the Judge Question case. Question's case was an interim order, not order of the court upon the final determination of the case on its merit. This one, the case has been heard on its merit, and the final judgment pronounced.
Okay.
Then you say that I believe you disrespect the orders of the court because you have merely filed some papers with the court. The effect of the order is that don't submit yourself to the rerun. When you submit yourself to the rerun, then you can take advantage of other remediable processes available to you under law. Where equities are equal, the time must prevail.
But won't it be injurious to his human rights if after his I need education. No. I need you. No. I will need you to educate all of us. We're all listening to you. So it's good that you take time to educate us. Now, won't it be injurious to him if after filing his stay of execution, knowing that for the pendency of the appeal, if you do declare his seat, you say that there should be a rerun, and his stay of when his appeal is heard and he wins, but you've elected another MP, won't it go against him if you do that without listening to the appeal, or without letting argument, hearing argument for the appeal that he's filed?
Mr. President. So let me respond.
Good.
The entities that have suffered a greater harm is the NEC and my colleague MP Isang. He was one who used.
Unfortunately, the line isn't helping us.
So if anybody
let me bring in Gary Nimako here. He's director of the legal affairs for the MPP. Gary, we understand that the member of parliament and lawyers for your party and him have been able to file a stay of execution and a notice of appeal against this ruling. But Honorable Dafeamekpor says that this does not really mean that he can still stay in the house. What's your understanding of the processes?
Let me say good evening to you, good evening to our child listeners, good evening to Honorable Dafeamekpor. Let me put it on record that I don't want to be seen to be arguing my case on the radio. But just for public education, I will just state a few points for your public to understand something. There are multiple processes filed in court, some at the Supreme Court, some at the High Court in Tamale, and some at the Court of Appeal. Now, just for a little clarity, you will realize that today, at around 3 p.m., application for judicial review was filed at the Supreme Court, and same has been said on Parliament this afternoon. And what we are simply saying is that the court, the High Court judge in Tamale, committed a jurisdictional error when he assumed jurisdiction to hear and determine the petition, which was filed by the petitioner on 25th day of January 2025. Because at the time that the petition was filed, it was filed outside the mandatory statutory period of 21 days. Now, the Gazette of the Pandai Parliamentary elections was gazetted on the 24th of December 2024. Now, any lawyer knows that once a gazette has been published by the Electoral Commission, you can file your petition within 21 days from the date of publication of the gazette. This particular petition that was filed before the High Court Tamale was filed on the 25th of January 2025, clearly falling outside the 21-day mandatory period. So I'm at a loss. I'm really at a loss how a High Court judge who sees jurisdiction when he knew he had no jurisdiction will be able to take a petition when they are far out of time. Security for cost was paid on the 27th of January 2025, and they couldn't detect these illegalities. I'm surprised. I am surprised. But subtract 25th January 2025 from 24th December 2024. It is 32 clear days. 32 clear days when it was filed. So clearly, the judge had no business entertaining the petition in front of him, let alone conduct a full-blown hearing and write a judgment that we are seeing today. So Parliament has been set before the Supreme Court. And I think that anybody at all who has seen this process will take a second look and say, look, let us pause. Some substantial injustice has occurred somebody. Honorable Nyindam has suffered a substantial miscarriage of justice before the court. And the Supreme Court must correct this injustice. Because we are simply saying that at the time when the petition was filed, clearly, the court ought not to have even heard the matter at all, let alone proceed to do a hearing and proceed to give a judgment on 24th of November 2024. So at this stage, all I can say is that we are waiting for the Supreme Court to hear the matter on the 16th of December. It's a Tuesday. The Supreme Court hears the matter and it tells one way or the other. That will chart the path of the way we are all going to go. But clearly, I'm telling you, any lawyer who is published in our courts knows too well that petitions are filed 21 days within the notification.
Well,
not outside.
Okay, but
within, not outside.
Does the filing of a stay of execution and the process that you've begun, doesn't necessarily stay the hands of the EC from executing the orders to organize a fresh election?
I didn't get your question right. Please, can you come again?
I'm asking whether the process that you've filed really stays the
Which of them? The one at the Supreme Court or the one at the High Court?
The stay of execution, for example.
Oh, the stay of execution, yeah.
Does it stay in the hand of the EC from organizing fresh elections as the court ruled?
Is it not fair that a decision has been taken, an appeal has been filed, okay? And then the man says, please, Court of Appeal, matter has been filed at the Court of Appeal. So hold your hands. Let's argue the stay application, which is before the High Court, or to be on the 10th of this month. So let's hear the stay application. If you say the stay application and one way or the other you decide that you want to grant or you not grant, that would change the direction. But how can you say that the person should leave Parliament even before the stay is heard? Why is this said? If the Supreme Court will decide that look, the judgments, the policies that were filed at the High Court, because it was far out of time, everything that is found is void of no legal effect, and then another time you have to take the seat vacant. What have we done to the MP? So why the haste? Why the indecent haste? Why the indecent haste?
But hasn't the court ruled that just by filing the process does not stay in the hand of any organization, constitutional organization, from doing its work? Just as Dafeamekpor was explaining earlier.
Your voice is very low, so I can hardly hear what you are saying.
Okay. I was asking that, Dafeamekpor was explaining to us earlier that
yes,
the court has held that just by filing a process does not necessarily mean a constitutional body cannot undertake its process. And that's why I'm asking that if the court indeed has ruled, can then the constitutional body go ahead and carry out?
Yeah, but when the court rules, there are processes where you can do the execution. Yes. There's a process for execution to be carried out. So they can trigger the execution process. We have triggered our state process and then filed at the Supreme Court. I just said Dafeamekpor, whether anybody can file petition after the 21-day period. Ask him. Let me answer you. Whether anybody can file petition after the 21-day mandatory period as provided for by law. Ask him. It is a void process.
Okay.
You can't file petition after 21-day period. You can't.
All right.
You can't. And you have seen this material breach, and we are challenging it at the Supreme Court. And you are saying that the Supreme Court should proceed. That's what they should declare the seat vacant. Why?
Okay. All right. So you're saying that tomorrow your client should be will be in Parliament.
Well, at this stage, all I'm saying is that we have triggered our process.
Okay.
They can trigger their process. Then the law take its own course.
Okay. All right. Thank you very much. Gary Nimako is MPP's Director of Legal Affairs. Let me bring in lawyer Samson Lardy Anyenini. Lawyer, with all that has been going on, what does the law really say? Does the man can he still be in the House tomorrow?
If you read the judgment, which is dated the 24th of November, the conclusion is this,
let's read it out. It is in the light of the various written addresses of the respective council for the parties that I hereby order a rerun of the Kpandai Parliamentary election to satisfy the constitutional requirement of free and fair current elections. Who is the order directed at? Do you see who the order is directed at in this ruling, in this judgment?
The Electoral Commission?
That is supposed to be the natural expectation because the Electoral Commission is the second defendant in the case, or second respondent. Do you see Parliament here? Parliament is not there. So let's put things in perspective and let's not begin to confuse issues that there is any order directed at Parliament. There's no order directed at Parliament. As we understand, and I think Rockson was hesitant to state, but on the day the judgment was given, it was premature to say that the MP should not be in Parliament. That was clear premature because the automatic 7-day stay after a judgment applied. If that applied and it expires, the pendency of the stay of execution before the High Court, I believe, and there's authority to that effect, should operate to still hold the scale, the balance equal, as it is now, the status quo, until it has been determined. If the High Court determines that it dismisses the stay of execution, you know that naturally they will repeat it to the Court of Appeal, which we all do all the time, because they are mandated to file it before the High Court. If they take it to the Court of Appeal, it is only about a week or within 2 weeks, and it will be heard. So I think all of the parties should be patient and not rush. If it goes to the Court of Appeal and within 2 weeks it will be determined, they should wait for it to be determined. If the Court of Appeal says, no, a rerun should go on whilst the appeal itself is being heard, that's a different issue. But a Court of Appeal will also, what will weigh on its mind is whether it's going to allow the state to sink money into a rerun, and then when the determination of the appeal is done, then eventually it confirms that perhaps the High Court decision was not right, and then we have to, that must be a waste of money, isn't it? Then you have to do the process all over again, or the person goes back into their position. Would have wasted money. As we are speaking, they say there's another application to the Court of Supreme Court for certiorari. So I think both parties must not be in a hurry at all. And by my reading of the law and reason, I think they ought to all exercise patience and allow the processes to run their course.
Okay. All right. Grateful to you. Lawyer Samson, Lardy, Anyenini. That's how we wrap up the story here. Brought to you by Telecel, Holy Insecticide Spray and Coil, and also by Shield Pension Trust. Into the future with you. Up next is Newsnight.